كلية الفقه الحنفي تقدم
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to lesson number 8 of shahadat, of witnesses. Allah subhanahu wa ta'ala bless us. Allah give us understanding. Allah allow us to use this in the proper way and accept us for the service of His deen. So today we're going to finish off with a few other people that are not allowed to bear witness. And then we're going to discuss how in an Islamic state, how non-Muslims, if there's a case involving non-Muslims, how who's acceptable in that regard as witness and who is not acceptable. And then there's a few other things related to things related to uprightness and so on and so forth, about doing some sins and can they be forgiven and can they then become witness or not. So inshallah that's what we'll be looking at. So the next point that he makes is walal muqamir bin nard, and nobody who's gambling using backgammon or chess. So a person who gambles, I guess a person who openly gambles is a person who's a fasiq anyway, but even a person who gambles using chess or backgammon, that is also considered to be somebody dropped. So these are, he's just, what he's doing is that the author, they're relating things that were seen as the few things in those days. Nowadays you have so many more issues. Especially online, people doing some crazy stuff online, right? And haram stuff online, various different scams. Anybody who's known to be a scammer, for example, anybody who's teaching other people how to, you can say, cheat the system, for example. All of this would be open fisk, especially if they're doing it openly. If they're doing it openly, then that makes it fasiq. If somebody's doing it secretly and they're trying to hide it, at least, then they're not open fasiqs at least. ولا تقبل أيضا شهادة من يفعل الأفعال المستخفة. Subhanallah. The testimony of somebody who does lowly acts, demeaning acts, right? That مما يخل بالمروءة, something that would not be something that would be considered indecent, right, among normal decent people. That would also drop a person's shahada. He gives a few examples, right? كالبول على الطريق, somebody who's known to urinate in pathways, right, unless it's a proper place made for urination, like a public toilet. This is talking about just outwardly. Well, akli ala tariq, this is an interesting one, just eating in public, right, unless there's a proper seating arrangement and so on, but if it's eating in public, they're just walking around eating. This is not talking about having a picnic in a park. That's seen as decent, right, usually, but it's talking about just a person just on the side of the road eating. Of course, if you're very, very hungry, or you got some serious issue and you need to take a bite, that's different. But he's talking about just somebody going around, look, in this indecent way. The reasons that's provided for that is that anybody who does this kind of indecent thing, they don't have any taboo, they don't have any restriction in their mind, they don't really care what people say or think. So why should they care about what Allah subhanahu wa ta'ala says? We're not talking about somebody who cares about what Allah thinks only but doesn't care about what people, so he's going to do what's correct in Sharia. We're not talking about that kind of person. We're talking about somebody who doesn't mind doing crazy stuff. In fact, they're like, I like to be rude, or I like to be vulgar, that's how I am. They're quite obvious, they're quite open about this, for example, because the Imam Maydani explains لأنه تارك للمروءة, because they are abandoning common decency. وإذا كان لا يستحي أن مثل ذلك, and if the person is not embarrassed to do these kind of things in public, right, لا يمتنع عن الكذب, right, they would probably not really be very careful. They probably won't avoid lying either. They'd be probably willing to, because it's all kind of connected. فيتهم, so that's why the person becomes suspicious in that regard. So we can't accept his testimony. Likewise, they say that in the old days it was a person who reveals themselves to go and even urinate or whatever, right? If the person, for example, is seen as okay in non-Muslim circles at least to change and basically bear all in an all-male setting or an all-male setting, which in Islam is not allowed, right? So that would be problematic as well. وَلَا تُقْبَلْ شَهَادَةُ مَنْ يُظْهِرُ سَبَّ السَّلَفِ. Again, the testimony of somebody who openly swears and curses rather at some of the Salaf, the Aslaf, the pious predecessors, right? As opposed to the one who does this, in a more subtle way, right? Because he's a fasik, but he's a hidden fasik, so we won't know about that. That's what he's trying to say. وَتُقْبَلْ شَهَادَةُ أَهْلِ الْأَهْوَاءِ. However, the testimony of these various different misguided sects is accepted. For example, the people who are innovators, because they have at least, while they might be completely mistaken and deluded with regards to their misunderstanding of the faith, whether it's innovation that they're adding or they go on to an extreme in one sense or something like that, right? As long as it's not a bid'ah, as long as it's not an innovation or a heresy that would lead them to disbelief, then they're not even Muslim anymore, right? But this is like the Jabariya or the Qadariya, the people, fatalists, or the people who believe in absolute free will, which was, you can say, a misguided academic position that they held, right, which is completely wrong, like the Mu'tazila held that opinion, or Raft, or a person who believes in the superiority of Ali radiallahu anh, but not maybe to the level of kufr. If it's to the level of kufr, then that's a different issue. Or is a Khariji, right, an extreme sect in that regard, or a person who has who can be charged for anthropomorphism, resembling Allah subhanahu wa ta'ala with his creation, or those who he describes as people who cancel out Allah subhanahu wa ta'ala having any attributes. So these are people who are kind of on the brink. They're not out fully necessarily, right, unless they go to an extreme. So he says that their shahada would be excellent, because in everything else they pray, they do everything else. It's just that they've got this deviant ideology. They're not progressives in the sense of, abandoning. So he's not mentioned, for example, the Murji'ah for some reason, who don't believe that good deeds are necessary, right, to do. They just think Iman is enough, right? He mentions Illa al-Khattabiyya, who were a group of the Rafidis, the Rafidi Shias. يَرَوْنَ الشَّهَادَةَ لِشِيعَتِهِمْ. They believe that you could give testimony, I guess even if it's incorrect, in favor of your own partisan people, right? So I guess that would not be allowed, because they would be, clearly they might even be telling the untruth, because it was allowed in their faith to tell the untruth, right? For their own benefit or their people's benefit. Okay, now moving on to the next section, which is about testimony or for cases involving non-Muslims, right? Dhimmis in an Islamic state. Obviously that would be, people who are citizens of the Islamic state, but they're non-Muslim. They've chosen to keep their faith. So what do we do in that case? وَتُقْبَلْ شَهَادَةُ أَهْلِ الذِّمَّةِ بَعْضِهِمْ عَلَى بَعْضٍ. So in between them, if there's a case involving just some Christians or Jews, non-Muslims within a Muslim state, they can bring witnesses of their own faith, right, with a certain standing. Okay, so they have that authority between them. وَإِنِ اخْتَلَفَتْ مِلَلُهُمْ كَالْيَهُودِ وَالنَّصَارَى. In fact, we would allow a Christian to be a witness for a Jew, and a Jew to be a witness for Christians as well. So we're not going to impose on them that they must all be Christians in a case involving Christians, or all Jews in a case involving all Jews. Okay, so ultimately we're going to see all of them as one, so they can do that between them. Now, if there's a foreigner from a abode of war, what they call a harbi, there's a distinction between a dhimmi and a harbi from an abode of war. A citizen of a Muslim state and a citizen of an enemy state. In the time when these things were there all over the place, and today we have that in terms of certain countries as well. So وَلَا تُقْبَلْ شَهَادَةُ الْحَرْبِيِّ عَلَى الذِّمِّيِّ. So a testimony given by a foreign person from an enemy state against a dhimmi will not be accepted either, even though they may both be of another faith, but they're not, it's not accepted. Okay, so that was in brief. He didn't make that too detailed. And Yeah, people who have come to an Islamic abode from another country, they can testify for one another. That would be okay, right? Even if they're from if they're from one place, that's fine. Now let's move on to the next section, which is, again, I think sometimes the discussion is a bit disjointed. He could have probably discussed everything related to uprightness right at the beginning, all in one place, but he mentioned all that, then he mentioned a number of scenarios and people and so on, and who's accepted. Now he goes back to discuss exactly what level of uprightness, because he didn't discuss that much in detail there. He goes to discuss that here. وَإِنْ كَانَتِ الْحَسَنَاتُ أَغْلَبْ مِنَ السَّيِّئَاتِ. So you've got somebody who does good deeds and some bad deeds, right? But his good deeds are dominant over the bad deeds. What we're referring to good and bad deeds here are not major sins, but minor sins. Person does minor sins, but his good deeds are usually over them, are overwhelming the bad deeds as such. And he doesn't do any major bad deeds at all, right? وَالرَّجُلُ مِمَّنْ يَجْتَنِبُ الْكَبَائِرِ. And this is a person who avoids the major sins. قُبِلَتْ شَهَادَتُهُ. Even though he's got some minor bad deeds, his shahada is going to be accepted. That's why in the Jawhara, which is a commentary of the Quduri as well, he says that this is the limit of valid uprightness. This is what we're going to look at. That he can do some minor sins, but he can't have any major sins openly, right? And his good obviously has to dominate his evil. So he's saying that it's actually necessary that they can't have any major sins though. So after that, if they avoid any major sins, then it just depends on their dominant state of good deeds. So if they're dominantly good deeds, then alhamdulillah, that's fine. Because he's saying that if there's somebody who has dominantly bad deeds, minor sins, doesn't do major sins, but dominantly minor sins, then you can't really trust them. Because if they're willing to not be cautious in so many different smaller sins, right, and not avoid them, then it means that they could probably lie once in a while as well. However, the person who sins sometimes, minor sins, every now and then they might sin, do something, right, speak to a woman, right, is considered a minor sin unless it gets serious, right, then his shahada will be accepted. Because if we were to be too strict in this regard and say you can't even have minor sins, then we won't find any witnesses, because many people fall. Many people have weakness in this regard, right? So we have to keep this door open somehow, otherwise our rights, people won't be able to ascertain their rights, because you just can't find witnesses. Can you imagine it? And that's why in the Hidayah, the Mushtaba Muhtaratul Nawazil says that this is the Sahih and sound opinion with regards to what is considered to be valid reliability and valid uprightness. To clarify further, then he says, وَإِنْ أَلَمَّ بِمَعْصِيَةٍ. Even if he is to fall into some misdeeds sometimes, then as long as he avoids the major sins and mostly does good deeds, then falling into some minor sins here and there, because Imam Maidani clarifies that everybody aside from the prophets are eventually going to fall and do something like that. So it would be very, very difficult to continue our judicial system otherwise. So the conclusion is أَنَّ مَنِ ارْتَكَبَ كَبِيرَةً. Anybody who does major sins openly, right? أو أصر على صغيرة, or is regularly doing minor sins, then his سقطت عدالته, his adala will be saqit, meaning he cannot stand as a witness in court. That would be the conclusion of this whole discussion. Alright. Now, there are some other people who are seen in the Sharia as people of problematic in some sense. So what he's going to do in this section is that he's going to clarify whether they are seen as people whose shahada drops or not, right? Even though people in general might see them to be indecent or problematic, not necessarily indecent but problematic. It says وَتُقْبَلْ شَهَادَةُ الْأَقْلَفِ. A person, uncircumcised person, his witness will be accepted, right? In some cultures, circumcision, in the Hanafi madhab, it's necessary to circumcise, but if a person becomes a new Muslim and is older, it's not obligatory. It's good to do so, but if it's difficult and can't find a wife to do it or something, then which is going to be unlikely, right? Or likely that he won't find a wife like that or something like that, then he doesn't have to, whereas it's obligatory in some other madhabs. Because that really doesn't really deal with, it's a very personal kind of issue and doesn't really affect the adala, the uprightness of a person. Unless the person doesn't do it because there's a family, they don't get anybody circumcised because they look down on it, they think it's wrong, it's not part of the deen, then that would be a problematic case, that would be sinful, right? So the person would not be able to stand in court for that. Likewise, a person who is castrated, because usually a castrated person is somebody who's been oppressed, who's been castrated wrongfully, right? So that's usually why. Of course, if he does it himself for, for whatever reason, to cross gender or whatever the case is, that would be problematic. Likewise, a child of fornication, an illegitimate child, it's not his fault, so he can stand in court as long as he's decent. He should not be having to carry his parents' sin. Likewise, a person who is a hermaphrodite, right? Hermaphrodite, theirs will be accepted, especially if they're determined to be male or female, then it's fine. And yeah, although he's going to be dealt with more like a woman, right? The hermaphrodite is going to be dealt more like a female. Now we move on to the next section, which deals with the witness that's being provided. There's some incongruency between that and the claim in the case. So whatever the lawsuit is, there doesn't seem to be complete harmony between the witness. So can you accept that? How different is the toleration? How much difference can be tolerated, and so on. So he's saying وَإِذَا وَافَقَتْ الشَّهَادَةُ وَالدَّعْوَةُ. If the testimony is completely, right, in accordance with the claim, لَفْظًا وَمَعْنًا. Now this is where you'll have to listen a bit more carefully, right? Because it's a new idea, so you need to get the framework in your mind of it. If it's the same, right, the testimony that's provided, the witness that's provided is exactly the same as the claim, both in wording and in essence, in substance, in meaning, or it is by wording it's separate but it amounts to the same thing in essence, then that has to be accepted, because it doesn't have to be said in 100% same way. Yes, ashhadu has to be said, but in terms of the actual scene, that I bear witness, I testify that he did do a transaction with him. You could say that. You could say he sold to him, he did a financial transaction to him. So there could be multiple ways, as long as they're not too elusive, that would relate to that. So one is that if he said it exactly as the case that the case was that he sold me this for £100. So this guy also says, I testify that he sold this to him for £100. That would be the same both in word and substance. But if he said, yes, he did transfer to him that for £100, so that essentially is saying it in different words, but the essence is the same, right? So that would be accepted. However, if there's a discrepancy, if there's a difference, both in terms of what the wording they use and also the meaning of what they're saying is saying something completely different, that he bought from him rather than he sold to him, for example, or that he gifted to him, that'd be completely different. Lam tuqbal, that would not be accepted. So how can you accept that, right? They're talking about totally different things. Now, that's in terms of the claim and the testimony. What about the two witnesses, the wording they use, does that have to be the same in between them? Does that have to be equally the same? So ويعتبر اتفاق الشاهدين في اللفظ والمعنى جميعا بطريق الوضع لا التضمن عند أبي حنيفة. Now this is where it gets a bit more complicated. Okay, you'll understand better from an example. So let's just say that I'll translate this first. And then when he provides the example, so he says ويعتبر اتفاق الشاهدين في اللفظ والمعنى جميعا بطريق الوضع لا التضمن عند أبي حنيفة. It's a condition to consider that both the witnesses must be in harmony with regards to the wording they use and the substance of their message. In terms of wada' and tadammun, in terms of wada', not necessarily tadammun according to Abu Hanifa. I'll explain that. Whereas according to the Sahibain, it's sufficient for them, for the two witnesses to just agree on the, to address it in a way that both messages say the same thing in substance. Okay, so the next part will highlight this more clearly. فَإِنْ شَهِدَ أَحَدُهُمَا بِأَلْفٍ وَالْآخَرُ بِأَلْفَيْنِ. If one of them bears witness to person B owing person A 1,000, the other one says no, he owes him 2,000. Okay, now وَالْمُدَّعِي يَدَّعِي الْأَلْفَيْنِ, and the claim is for 2,000. So let's say the claim was for 2,000. The two witnesses, one is saying he owes him 1,000 and the other one is saying 2,000. Now that means they both agree that at least 1,000 is owed, but it doesn't match up. At least that one person doesn't match up with the 2,000, which was the original claim. لم تقبل الشهادة عند أبي حنيفة. Imam Abu Hanifa will not accept that. Right? Because the claim was for 2,000, we need witnesses for 2,000. There's only one witness for 2,000, that's not enough. Right? There's only one witness for 2,000. He says the reason is that there's a difference between them in terms of the wording, right? In terms of word. One is saying alfain. Now this you have to understand Arabic for this a bit. The word alfun means 1,000. Alfaini is the dual form of 1,000, right? Which means 2,000. Now, وذلك بدل على اختلاف المعنى لأنه يستفاد باللفظ وذلك لأن الألف لا يعبر به عن الألفين. So there's no way you could take that one witness's statement as he owes him 1,000 to mean 2,000. It does not encompass the meaning of 2,000. There's no way you could. It doesn't have tadammun. It doesn't have. It does not consist of that meaning. It can't allude even to that meaning. Alf is 1,000, and alfain is 2,000. So these are going to be considered according to him completely two separate statements, 1,000, 2,000. So it is as if they have differed with regards to one saying he owes dollars and the other one saying he owes pounds. That's how bad he sees this difference. Okay, so Sahibain, they say the claim is going to be valid for up to 1,000, right? Because they both agree to alf, right? They both agreed to 1,000 and 1,000. So they would accept it up to 1,000, not to 2,000, but they accept it up to 1,000. What they're saying essentially is that both the witnesses, they're agreeing to 1,000 being owed. One of them is adding the 1,000 extra. So at least the part that they agree on, which is 1,000, that will be established. And that would be the same as if one had said 1,000 and the other one had said 1,500, literally in those words, alf wa khamsumia. So this is a bit more difficult to understand in English, with the English wording, but in Arabic the word alf and alfain, they're two separate words. Sahibain are fine because they're saying that alfain incorporates alf within it, 1,000 within it, 2,000 incorporates 1,000. It's fine, right? Whereas Imam Abu Hanifa says no, there's no way that the alfain, that's fine according to what the claim is, but the alf, does not represent 2000 in any way, so we can't do anything with this. Sahibain say we can do something with it. We can establish 1000 at least, because alfain, 2000, incorporates 1000 in it. Okay, so they're saying it's similar to a person saying, one of them saying he owes 1000 and the other one saying 1500. So at least the 1500, which Imam Abu Hanifa would agree with as well, 1000 and 1000, they would both agree at least on 1000 in wording. So Imam Abu Hanifa looks at the words. So if somebody had said 1000 and 1500, then at least they both said 1000. So that much would be at least the same. But in 1000 or alf and alfain, which is 2000, in English it'd be fine because they're both saying 1000. But in Arabic, alf and alfain are two separate words. So he's saying similarly you deal with the case of mi'a and mi'atan, which again is a proper Arabic word for 100, right? It has a proper word called mi'a, which means 100, right? It's not digits, right? 100 and 200. So mi'a and mi'atan, and talqa and talqatan, if the issue was about one divorce or two divorces. This is usually going to be the case in all dual words, because in Arabic it has a special form for dual words before it goes into the plural of it. Isbi Jabi says that the Sahih opinion is Imam Abu Hanifa's opinion, and that is what they've dealt with. Now, this is all in the case where the claim was 2000. Because if the claim was 1000, then لا تقبل الشهادة بالإجماع, none of them would agree with it. None of them would agree with it if one person said 2000 and the other person would have said 1000, because the 2000 in wording as well does not incorporate the 1000. So this is because this will become actually more clearer when I read the next part to you. So وَإِنْ شَهِدَ أَحَدُهُمَا بِأَلْفٍ, one of them bears witness to 1000 that he owes him 1000, وَالْآخَرْ بِأَلْفٍ وَخَمْسِمِئَةٍ, right? This is where it's going to become clearer. The other one says no, he owes him 1100, I can bear witness to that. Now if the owner, if the claimant, his claim in this case was for 1500, then both of their witnesses for 1000 would be accepted according to Imam Abu Hanifa and Imam Abu Yusuf and Muhammad. Why? Because look at the wording. Alfun means 1000. Alfun means 1000. Wa khamsumi'ah means 500. So one is saying, witness A saying alf, witness B is saying alf wa khamsumi'ah. That means in wording they both agree on alf at least, plus one. So they both are saying the same words. So even Imam Abu Hanifa accept that. He doesn't look at just substance, he insists that the words incorporate the same meaning, can hold the same meaning. Alf and alfain was totally different because alf did not incorporate 2000s. So in this case he's saying both Sahibain would agree with it because they look at the meaning that yes, it's there, and the reason why they're not going to use it to establish 1500 because there's only one witness, which is witness B, who's saying 1500 or 1500 rather, right? The other one is saying just 1000, so they don't have proof for 1500, but they have proof for just 1000 because of the wording that's used, alf and alf wa khamsumi'ah. So alf is basically the common factor, so they can establish alf. لِإِتِّفَاقِ الشَّاهِدِينَ عَلَيْهَا لَفْظًا وَمَعْنًا, because the two witnesses are in agreement in wording and meaning on at least 1000. لأن الألف وخمسمائة جملتان. Why? Because when he said 1500 in Arabic, alf wa khamsumi'ah, 1000 and 500, that's two jumlas, that's two clauses, that's two parts of the statement. One is conjugated with the other, right? So that shows that they're two separate statements. It's not part of one statement. It's part of two. It's two clauses. It is one statement, but part of two clauses. So you can take the first part separately. That's in agreement with number one, with person A's saying that 1000, right? So that much you can establish 1000. Likewise, if somebody crazily has said that he gave me 1.5 divorces. So the one witness says yes, it was one divorce, the other one says it was one divorce and a half. So at least they're both agreeing on one divorce, and then the half can be ignored, right? Likewise saying, if there's a claim, let's say the guy claims that he owes me 150. The one witness says I testify that he owes him 100 only. The other one says, I testify he owes him 150. So because they're two separate clauses there, 100 and 100, they both agree on that, so they can establish 100, but they can't establish 150. As opposed to, now this again, you have to know Arabic for this, right? Or understand it at least. As opposed to if it was a case of between 5 and 15. Now even in English, 5 and 15, 15 does not include a 5. Right? And neither in Arabic it does, but it's not, it's part of the same clause even. 5 in Arabic is khamsa. And 15 in Arabic is khamsata ashar. Khamsata ashar. There's no conjugation in between and. It's just 5, 10 to literally translate it. So 5, 10 cannot be separated according to Imam Abu Hanifa because it's all one word. In fact, it's like seen as one clause. So you can't pull out 5 from there. If he said khamsata wa ashara, 5 and 10, that would have been okay. But 15 is not said like that. So khamsa is 5 and ashar is 15. So he's saying لأنه ليس بينهما حرف العطف, there's no conjugation in between to separate them out that we can just take one. We're going to have to take it either fully. If we take it fully, it's completely different from 5. So they're not agreeing in wording, right? So that's the same as 1,000 and alf and alfain, 1,000 and 2,000, right? Hopefully that's clear. Now the next point, which is similar to this, وَإِذَا شَهِدَ بِأَلْفٍ, right? So one of them gives witness to 1,000. وقال أحدهما في شهادته لكنه قد قضاه منها 500 قبل شهادته ب1000 لاتفاقهما عليه ولم يسمع قوله إنه قضاه لأنه شهادة فرض إلا أن يشهد معه آخر ليتم نصاب الشهادة. It's going to a slightly variant scenario. So both of them actually bore witness to 1,000. But then one decided to say during his witness, right, person A decided to say, however, he's paid off a 500 of that. So he's saying that yes, the claimant is owed 1,000 by the next person, but he's already paid him 500. So he's already paid him 500. So yes, he owes him 1,000, but he's already paid off 500. So does that make it 500 now? No. His witness to say the 1,000 would be accepted, and the other part where he says and he paid off 500, that would be disregarded because the question is not about repayment. The question is about, did he owe him £1,000 or not? So he said yes, he owed him £1,000, but he paid him back 500. Right? That's besides the point, because the claim is not about how much he's repaid. The claim is about he owed me 1,000. Okay? So that much they're both agreeing on now, right? The first witness says yes, he owes him 1,000, and the second witness says yes, he owes him 1,000, but 500. So 500, you ignore that part because both of these are congruent with one another. That will be accepted. Okay. وَلَمْ يُسْمَعْ قَوْلُهُ إِنَّهُ قَضَاهُ. So the second part of it is not going to be, is not going to be relevant in court because the debate is not about that, and that's only one person saying it. It's only one witness saying it, right? So that's not acceptable, right? Both witnesses agree on 1,000 being owed, and then the other part is not إِلَّا أَن يَشْهَدَ مَعَهُ آخَرْ, unless the first witness also says, yeah, he gave him £500 back as well. Because then it's two people saying it's only 500 that's actually owed. وينبغي للشاهد إذا علم ذلك إذا علم قضاء المدين وخشي إنكار المدعي لما قبضه أن لا يشهد له ب1000 حتى يكن المدعي أنه قبض 500. Now, in order to avoid this, there's a way that he's going to discuss for this, inshallah. So rather than do it in the way he did it, he says that it is appropriate for the witness, if he knows that some part of it has been repaid, and he fears that the claimant who he's witnessing for is going to deny that he's been paid anything back, right? He should not witness, he should not testify to 1,000 to start with, right? Until either the claimant first makes it clear that yes, he owed me 1,000, but he's taken 500 back, that he's given me 500 back, right? just so that he does not help him in his oppression. Because this is a court situation and there's very rigid ways of looking at wording, but that doesn't mean that you use that to wrong somebody. So that you don't fall into that previous scenario, right? That you're just going to say 1,000, but he paid him back, and that's not going to listen to unless both witnesses are willing to say that. You say, oh, I only know him to owe him £500, for example, or to establish the 1,000, but make sure that the claimant is making it very clear that yes, it was 1,000, but he's paid me 500 back already, right? So there's another case I'll just deal with, which is the case of murder, right? Just to finish off today, we'll deal with that. وَإِذَا شَهِدَ شَاهِدَانِ أَنَّ زَيْدًا قُتِلَ يَوْمَ النَّهْرِ. If there's two witnesses who have provided their witness that Zayd was killed on the day of Eid, Yawm al-Nahr, this year in Mecca. That was the detail. He was killed on the day of Eid in Mecca. Okay, cool. We've got two witnesses, right? Should be done, right? However, there's two other witnesses. There were four witnesses brought there. Two other witnesses. They're saying that no, he was killed on the day of Eid this year, but it was in Kufa instead. It was in London instead. It wasn't in Mecca. And all four of them are there. For some reason, because of a serious issue, they've called four witnesses. None of these two and two would be accepted because there's a massive conflict between them and it's all done at the same time. Because clearly one of them is wrong, one of them is lying. Clearly one of them is lying, because I mean he can't have been killed in both places at the same time. And there's no way to give precedence to one over the other, so what are you going to do? Yes, if one of them had provided the evidence testimony first, and the judge had made a judgment with it already, you know, the Makkah one or the London one or the Kufa one, then the other witnesses had come in, they wouldn't be accepted because now they're trying to change a case that's already done and dusted, right? There's already the first set of testimonies have the judgment attached to it, so it's done, right? So that then you can't break the other one, right? Okay, so Jazakallah khairan. Inshallah we'll see you in the next lesson.